Welcome to We Chat Divorce, hosted by Karen Shalhoub, Legal Liaison, and Catherine Shanahan, CDFA. Each episode, we sit down with divorce professionals and industry experts to provide insights and frank discussions about real people, real situations, and real divorce to help you achieve your best life post-divorce. This episode of We Chat Divorce is brought to you by My Divorce Solution, offering divorce financial planning so clients can secure the divorce settlement they deserve. Visit mydivorcesolution.com to request access.
Hello, everyone. Welcome back to We Chat Divorce. I'm Catherine Shanahan, divorce financial specialist and co-founder of My Divorce Solution. I'm also your partner in turning chaos into clarity.
And I'm Karen Shalhoub, legal liaison and co-founder, here to keep you grounded in the process while Catherine wrangles the numbers. Together, we'll break down the real-life roadblocks you tell us about every week.
Gosh, Karen, today is a big one. As a matter of fact, I feel like I had this conversation, you probably did too, with some of our clients over the last couple of weeks. So today's roadblock is a big one. It's your mediation date is set and the clock is ticking. And your spouse still hasn't handing over the bank statements, the 401k summary, maybe anything beyond just a couple of screenshots.
And that happens 90% of the time. I think we can confidently say that. And we know that sick to your stomach feeling, because without complete information, mediation can feel like negotiating in the dark. And all while you're being advised that maybe other things will be resolved at mediation. It's a very common conversation. So in the next 30 minutes, we're going to give you a step-by-step playbook for what to do right now, from the friendly nudge email to the do we pause or push forward decision.
Yeah. And if you ever worried that asking for documents will rock the boat, as they say, stick around, because we're going to give you enough confidence that will show you how getting the facts is not aggression, it's protection, actually.
So grab your coffee, your notebook, and let's dive into mediation with missing numbers.
Oh, gosh. So let's give a scenario, actually. We have a client, let's just call her Lisa, and her mediation is next week or even tomorrow. And she's produced everything, 5 years of bank records, whatever has been asked for, done her expenses, or I should say completed her expenses several times, and she's ready to go. But her husband, let's call him Rob, sent 3 screenshots of a checking account, period, end of story. So now what do? How do you actually reconcile numbers to actually try to mediate?
Right. And the conversation that you may be getting from your spouse, if you're doing private mediation or court mediation, is let's just get started. Sometimes your attorney may think that they already have it figured out, or that you're going to show up for mediation to get more documents. And the fact that your spouse hasn't provided sufficient documentation seems to be way down at the bottom of the list. So why do complete documents matter? Well, mediators rely on shared facts to create options. So often they're seeing half-baked, data-skewed proposal, and lets one side of the room control the narrative. Catherine, how many times have you seen that? Because you're a trained mediator. All of our divorce financial specialists here are trained mediators. Talk about that a little bit, how that dynamic happens not only in private mediation, but in court mediation.
Yeah. Well, I love that I have the aspect of, or I should say the viewpoint of a CDFA who's a trained mediator, right? So I'm a financial mediator. And of course, we have to verify things with documentations. And I can believe a spouse's spreadsheet, and spreadsheets look so beautiful, and especially to people who aren't comfortable around numbers. You hand them a nice spreadsheet and they're going to believe it, just because how do you argue it? But for me, when I need the document to support that data, right? And so then once it's verified, okay, we could take that to mediation and we can have a really good discussion. But what happens is you go into mediation and you have a spouse who's been the controller of information and finances, and they present this spreadsheet or Word document, and they actually even sometimes sit there and work on it on their computer. So it looks very legit. And so I feel bad for the other spouse who's sitting there saying, how do I argue against this? Because on the third party neutral, that mediator is saying, well, what do you want? Does these numbers look good to you? Can you live off of that? That's a lot of money. You'll be okay, right? So how do you know what you want if you don't actually know what's there other than numbers that are being shown on a screen? That's not really fair. You know, you
Right.
can't really do that. That's not fair to the other party. And that's why people live with regret. And that's why we always hear, gosh, I wish I would have met you 5 years ago.
Yeah. And there's a couple of different scenarios there. We're involved in a case right now where we were speaking with the attorney. We're working with the client financially, and they're pushing the case forward. And the attorney looked straight at us and said, spouse has provided so much information and documentation. It's really hard for us to push back and say we need more.
Oh
And
my
I was
gosh, does that
dumbfounded.
aggravate us? I know. Well, yeah, I could throw you up the last 7 years of every piece of paper that I have and throw it on your desk. You're never going to look at it, for one. And number two is, what is that? What does that have to do with the missing information that you need to make really good decisions?
100%. And I think we said that to them. Yes, he has provided the same documentation about 3 times now, but clearly there's the critical information that remains missing. And everybody wants to push forward because you're tired of weeding through documents. So, how do you address the situation? So, that's the solution we had to talk about. And people do need to understand that courts in every state require full financial disclosure before a settlement is final. And so many attorneys and or mediators and even or your spouse may say, well, before settlement is final, that all will be delivered. But how are you supposed to mediate short of that? And what if your attorney wants you to go to mediation without that disclosure? Frankly, most of the time they do, because it's not easy for them to push the agenda that we need everything before we can start mediation. And frankly, you as a client may feel like, well, if we can settle in mediation, I don't want to use the court system. I want to do it as amicably as possible. And so you're kind of arguing with yourself all the time. Do I hold my space, or do I see what we can do in mediation? It is a tough decision. And sometimes people are just not ready to take a strong, confident stance because they get confused with aggression versus protection.
It's a really good point. You know, but you also said something there that really aggravates the shit out of me. I know this for sure. And that is, you said, and correct me if I'm wrong how you said it, but you said the courts require full financial disclosure. And it's written in agreements. But if you're listening to this right now, I would love you to send us a message on how many of you did not get full financial disclosure, even though it says the courts the courts require it. Karen,
Mhm.
there's so many cases, if not all of them, that full financial disclosure is never really attained by one of the parties. And so they just come to settlement agreements then, because everybody gets worn out.
Absolutely. And a fallacy that happens is the attorneys say all the time, I'm on calls all the time where this happens, or even a mediator. We even say it. Well, if your spouse doesn't disclose an asset, then you can go after it later, after the divorce, if it becomes known. However, the situation is the spouse may have said, well, I have Coinbase accounts, or I have a business, or I have these assets. That is disclosure. That doesn't give you, typically, from how I understand attorneys to reply back to us, that doesn't mean you have anything to go after afterwards, because that essentially becomes the disclosure for it. We even have a case where the spouse gave the sworn affidavit and said, see attached. The attachment didn't say anything about being a part of the disclosure. And so it has become this huge thing where the spouse will not sign that the attachment is a part of the disclosure. And 6 months later, we're still waiting for full disclosure. So there's so much nuance in those discussions, but it's important. It really
Really
is
important.
important.
Really
Yeah,
important. And unfortunately, that 6 months of period that you just mentioned probably cost the client what, $50,000 of
at
communication to go nowhere.
minimum,
Yeah, which I
minimum.
know is going to be on another podcast that we're going to speak about.
Yeah.
But it is really frustrating, because you never know. Do you move forward with mediation? Do you pause the mediation, or do you pivot and say, I'm not going to waste my time or money with a spouse that's not cooperating, and just ask for a trial date and really kind of light a fire under them? Hopefully that would scare them. But again, all of it can be really costly. But I say this, I might be digressing here a little bit, but when we talked about this documents, that's what I love about our process and the MDS method. And I swear every judge should require it because there's no reason why we need two attorneys collecting the same data. If parties want to save money getting divorced, and anyone we meet out there, because divorce affects everyone to some capacity, whether you know someone, you've gone through it one or two or maybe three times yourself, or you just have a friend that's going through it. There's nobody can explain to me why two attorneys are collecting the same data. And so our process is set up to collect that data. And sure, 10% of the cases will go to litigation. And so let them litigate over data. But be forthcoming with the information if you really want to save money on the attorney process.
Yeah.
And then have a symmetry of information, because you need that. And with us, even with the missing information, at least you know what some of your options are moving forward. Get organized financially. That's the best thing to do for yourself when you're preparing for mediation or anything else in the divorce process.
Yeah, absolutely. And it gives you a good perspective of where you want to spend money chasing assets that are not fully disclosed. That's super important. So let's do some pre-mediation triage here. Number one, and exactly what you're saying, is understand what your spouse has and has not provided. You need to at least know that. And sometimes people will say, well, I don't know. Well, that's why you need to develop an MDS portrait so you know where the holes are. That's so important. And then if mediation is scheduled, either, a lot of time the courts mandate mediation within a certain amount of time, or if you have mediation and you're scheduled and you don't feel that you're ready in a private mediation, you can put a list of these are the documents I know are missing. In order for us to have effective communication, please provide the documents listed on my attached list. That's very appropriate. And enough time, let's just say a week or so ahead of mediation, so that everybody has time not only to receive the information, to review the information. If you get information in less than 24 hours or even 48 hours, how can you even know what it is in order to effectively communicate at mediation? So mediation sounds wonderful, but if you're not using it the most effective way, that's mediation's going to fail. And so many people will be able to speak to that point.
Yeah. Yesterday, there was a case that I had to prepare a division scenario. And then I reached out to the attorney. Okay, last week you were requesting the updated statements from the other counsel for the spouse's information. And she said, yeah, I did request it, but has been no response. So I said, well, it's really hard to reconcile accounts without the statements, and you're going to mediation tomorrow. Like, makes no sense to me. But anyway, we'll see how that turned out. Go ahead. I didn't mean to
No, that's fine.
triage here, but
Yeah. Well, that's what I'm trying to convey here is that if you're headed towards mediation, you need a window of time for people to reach out either via your attorney, or if you're reaching out directly to your spouse in private mediation and copy your private mediator. We need these items before we can have an effective discussion. So then what do we do? And that's our next section in the playbook.
Where we say, why are you going to mediation? Of course, it's not our decision. We can only point out from your portrait what's missing and how we can't reconcile accounts to go to mediation. But I often hear clients tell us that their attorneys have said to them, we can't cancel this late. We can't postpone this late in the game. The mediator will get mad, or the other side will get mad, or they give you this pressure that you can't reschedule because it's too late and everybody will get mad at you.
That's true. So that's really important. It's going to go back one step here, that when mediation is scheduled, there's a plan, if missing documentation is out there, as to when it would be the discussion is appropriate. Do we pause, reschedule, or do we go? Because I'm telling you, it is not uncommon for people to get information within 24 hours of mediation and they move forward. And just because you have the documentation or even some of the documentation that's requested doesn't necessarily mean it's a green light. So that is definitely in the planning stage.
And if you feel bad that people are going to get mad because you're not ready, because information has not been provided to you, then go talk to your coach. Go talk to your therapist, talk to your coach about getting over being mad. because you have to
Mhm.
be really smart and you have to make decisions based on the information that you have, not based on the information that's missing.
And in that context, then you at least need to know if the information that is missing, how critical it is to have before you can make a confident settlement decision, right? So if you
Yeah.
need a KBB value of your car, that's easy, right? But if you
Yeah.
need a business valuation or if you need documents to support business activity, I don't know. Usually that's not negotiable. Uh,
Yeah. And by the way, a K1 is not a business valuation. And I was just thinking of another client going to mediation. What the value of the business was the K1. That's not the
yeah,
value of the business.
no. And the bank account balance is not the value of a business.
True. Yes. We're laughing, but we don't mean it to be a joke.
No.
Because, this is what we see all the time. That's not enough information. We do have a divorce checklist of information that you should have. Again, you can reach out to us and we're happy to get that to you.
Yeah. So let's go on to the decision point, Catherine. Go, pause, or pivot.
Yeah. Gosh, that's a hard one, right? And it's the only one that you can make for yourself. So rarely ideal is proceeding anyway, meaning proceeding without all the information needed. But some of you I know, because we hear it all the time, feel like you're just so anxious. You want to get to that mediation. You just want to have that next step occur. You feel like you're being pressured by your attorney to have that mediation because it's been scheduled for so long. And this is the best mediator that you're going to get, we hear oftentimes. So we don't want to mess that up. We don't want to make them mad. So for whatever reason that you feel like you need to proceed anyway, listen to your gut, when you're in that meeting. If it does not feel right, do not agree. You're not for mediation is not an enforcement to agree to something. If your gut is telling you this is not right, do not sign, no matter what they say, because the pressure will come down on you to sign. They all want to move on. The con to that is that it's a really big power imbalance. If you don't have the information, in divorce, knowledge is absolutely everything. And to remove the emotions from this, you have to have the data to support any decision you make, because that's making a really smart decision for yourself.
Absolutely.
The next one is asking for a short continuance and taking a pause. Maybe it's 1 to 3 weeks. So if you're really anxious to move forward, you don't have to ask for 6 months of continuance. You can just say, let's come back in 3 weeks and get the other side to get the mediator to get the other side to give you the missing information, get new dates, be prepared with what's missing when you go there so that you can leave it on the table and say, this is what I need to move forward. And it doesn't take 3 weeks for a lot of people to get information. So it doesn't have to be a really long continuance. And then the next one is pivoting. If you need to talk to your attorney about formal discovery, what does that look like? File or threaten the other side that you're going to do a motion to compel or you're going to issue subpoenas. Often that statement in itself, the other side does not want to go through that either. Some people like to keep things quiet. A lot of times if you're dealing with a narcissistic spouse, and this is your route, their ego is more important than some discovery. So,
Yeah.
they don't want
And
to be embarrassed.
I'm going to let everyone know that it's my experience that both mediators and attorneys take their cue from you, take their cue, CUE, from you. If you're tentative, if you're reticent to want to be proactive in these litigation measures or in, saying I need these documents, they're not going to force that on you. They're following your tenor in moving your case forward. Because short of that, if they go file a motion to compel without your consent and your approval and your buy-in, then you could be yelling at your attorney the next day for making your spouse mad at you via a series of texts that you just got overnight. So they definitely are following your lead relative to how you want the case to move forward. So a lot of people get angry with their attorney, but you are the client, and a healthy relationship with them is really important to the extent that you can establish that.
And that's really important to listen to what Karen just said, because your tenor will be the track of your divorce. And so the best way to equip yourself is to turn your fear into focus and turn that focus into knowledge. And that's why we have the portrait, because then you're driven on the documents and what they mean to you. What's the impact and what are the scenarios available to you? And if you know your A, B, or C scenario, financially speaking, what's there to confirm that these are your scenarios, what documents are missing with that, then your tenor to your attorney is going to be really powerful. You'll be able to stand behind documents and not stand behind emotions. And that really actually will make you sit a little straighter and walk into any meeting feeling really good about yourself.
And we're going to move on to the tools that can be used to get the information requested and necessary for your knowledge base. Attorneys can issue subpoenas. Mediators can ask for documentation to support your discussion. So many people take the position that, well, the judge is going to be really mad at my spouse. They're going to see that he or she didn't provide what was asked for. And I often say, and I ask attorneys to help their clients understand this, that no, the judges actually aren't going to be mad. They're going to be mad at counsel, attorneys, for not doing the work necessary to get the information and documentation in a way that both clients can make informed decisions. It's not the judge's role to determine who did what. Your attorney and your mediator, well, your mediator's not in litigation, but your attorney has the tools necessary to get the information in, whether it's subpoenas, motions, whatever it is, threatening letters, they have the tools necessary. And then they also have the ability to put protective clauses in the settlement if you feel that full disclosure hasn't been made, and they can go over that with you as well.
Yeah. So, I just want to point out again in conclusion that sometimes refusing to mediate is not a refusing to mediate. It's really asking for a pause, because sometimes it's the wisest move. A bad agreement is harder and costlier to fix than a delayed one. So again, get yourself prepared, know what you have, know what's missing, know what your scenarios are. And then, of course, try mediation if it's available to you. If not, work with your attorney to do all the other things that Karen just mentioned. And again, remember, knowledge is everything in divorce. And the only knowledge you can get can be based on data. That's what we do here at My Divorce Solution. We want to make sure you're financially informed to make really good decisions for yourself.
All right, friends, take a breath. Remember, complete, transparent numbers are not a luxury. They're a prerequisite for a settlement that actually sticks. If your spouse hasn't delivered, you now have the nudge email, the triage checklist, and the confidence to press pause if the playing field isn't level. And one favor for us, if this episode gave you a little courage, share it with someone who's feeling stuck in the dark. There's many out there. We see you, we've got you, and we'll be back with another Divorce Explored. Until then, keep your numbers clear and your future even clearer. Thank you for tuning in. We invite your questions or feedback always. We want to be discussing what is financially most important to you. Email us at hello@ck11.net with your questions or comments. Stay tuned for future episodes as we continue to unravel the fascinating world of finance and divorce. Remember, knowledge is power. And in Catherine's words, knowledge is everything in divorce. Disclaimer. The information provided in this podcast is for educational and informational purposes only and should not be considered as financial or legal advice. Please consult with professionals in the relevant fields for personalized guidance.
Thanks for joining us on another episode of We Chat Divorce. We hope this episode was informative and supportive on your divorce journey. If you're looking for more support for navigating divorce with confidence and clarity, head over to mydivorcesolution.com for more podcast episodes, divorce events, and resources for your divorce. We'll see you back here for our next episode.